Sentencing of criminal offences in Western Australia. It doesn't matter if the offender is found guilty at trial or pleads guilty, the sentencing process remains the same. When determining a sentence, the court is guided by two things. Firstly, the Sentencing Act of 1995 and relevant case law, which is often from the appeals jurisdiction of the Supreme Court. On the day of sentencing, the court will weigh a number of factors, including the circumstances of the offending, the criminal history of the offender, and the sentencing guidelines as prescribed by the Sentencing Act. Whether someone is facing a modest fine or serious jail time, it is important to understand the sentencing process for criminal offending. The Sentencing Act is the pivotal piece of legislation that outlines the framework for sentencing individuals convicted of criminal offences. Under the Act, a hierarchy of penalties is established, guiding judges to consider various sentencing options in order of their severity. This structured approach ensures that the sentencing process is methodical, fair, and proportionate to the seriousness of the offence. The range of possible penalties includes options such as no sentence, conditional release orders, fines, community-based orders, intensive supervision orders, suspended imprisonment orders, conditional suspended imprisonment orders, and, as a last resort, immediate imprisonment. This spectrum of penalties allows the judicial system to tailor sentences to the specific needs and circumstances of each case, ranging from lenient measures for minor offences to more severe punishments for serious crimes. The Act mandates that the last and most severe penalty, immediate imprisonment, cannot be imposed unless all other available penalties are considered inappropriate. This principle reflects the Act's emphasis on imprisonment as a sentence of last resort, to be used only when absolutely necessary, such as in cases where the severity of the offence or the need to protect the community justifies such a harsh measure. This approach underscores the Act's focus on rehabilitation and reintegration of offenders into society, prioritising alternative sentencing options that allow for correction and support rather than immediate punitive measures. The penalty imposed for a criminal offence is not predetermined, but rather depends on a combination of factors such as the specific nature of the offence, the offender's prior criminal record, and their personal circumstances. This approach ensures that the punishment is tailored and appropriate to each individual case. But how are these penalties determined? At sentencing, the court is required to consider all information relevant to ensuring that the sentence is fair and in line with case law. The offender's criminal history plays a pivotal role in the sentencing process. A first-time offender may receive a more lenient sentence compared to someone with a history of similar offences, reflecting the legal system's approach to rehabilitation and deterrence. The court assesses whether the individual has previously been convicted of similar or other serious offences, which could indicate a pattern of unlawful behaviour or disregard for the law. Personal circumstances of the offender are also taken into consideration. This includes factors like age, health, employment status, family responsibilities, and any efforts made towards rehabilitation. For example, a young offender with prospects for rehabilitation might be treated differently from an older, repeat offender. The court may also consider the impact of the sentence on the offender's dependents, employment, or health. A crucial element in determining the sentence is the gravity of the offence. This includes considering the harm caused or potential harm, the intent behind the offence, and any aggravating or mitigating factors that might influence the severity of the act. For instance, a crime committed with premeditation or that causes significant harm to others is likely to attract a more severe penalty than one committed impulsively or with minimal impact. Remorse significantly influences the sentencing of criminal offenders, primarily serving as an indicator of the offender's acknowledgement of their wrongdoing and their emotional and moral response to the consequences of their actions. Demonstrating genuine remorse can lead judges to consider more lenient sentencing options. This is based on the premise that an offender who shows sincere regret for their actions is more likely to engage in rehabilitation efforts and less likely to reoffend. The expression of remorse can be manifested in various forms, including direct apologies to victims, participation in restorative justice programs, or evidence of positive behavioural changes post-offence. These factors, which are specific to the individual case, are then considered in light of the legislation and relevant case law. Statutory penalties form the legal backbone of sentencing in criminal cases. These penalties are outlined in the legislation that defines the offence, providing a structured framework for courts to determine appropriate punishments. For instance, in the case of trespass, as defined under Section 70A of the Criminal Code, the statute specifies the penalty, which in this instance is imprisonment for up to 12 months and a fine of $12,000. This exemplifies how statutory penalties set a clear legal boundary for sentencing, ensuring consistency and fairness in the criminal justice system. The description of statutory penalties varies, giving courts a range of options for sentencing. Penalties are typically categorized into fines, community orders, imprisonment, or a combination of these, each tailored to address different types of offences and their severities. The precise description of these penalties plays a critical role in how they are interpreted and applied. Under the Sentencing Act 1995, these descriptions are not merely suggestive, but are legally binding, guiding the courts in their sentencing decisions. The concept of a penalty being described as a minimum or applying only in certain circumstances adds another layer of complexity. For instance, minimum penalties are common in road traffic offences, where the law often specifies a minimum fine and period of licence disqualification. In some cases, the statutory penalty may not explicitly state whether it is the minimum or maximum. In such scenarios, it is typically interpreted as the maximum penalty, giving the court the flexibility to impose a less severe punishment based on the specifics of the case. Other common descriptions include a fine or imprisonment, imprisonment only, and a fine only. Each of these descriptions has specific legal interpretations under the Sentencing Act, guiding judges in their decision-making process. For instance, fine and imprisonment means the court has the discretion to choose from any sentencing option available under the Act, barring the option of no sentence. In addition to statutory penalties, case law also guides sentencing by providing a history of judicial decisions that articulate how legislation should be applied in practice, especially in balancing the seriousness of the offending, personal factors of the offender, and other relevant circumstances. When judges consider the seriousness of offending, they look at precedents to gauge the gravity of the crime within a spectrum of similar cases. For instance, case law provides benchmarks for what constitutes serious harm, gross negligence, or high moral culpability in various contexts, helping to standardize sentencing decisions while allowing for the necessary flexibility based on the facts of each case. Personal factors of the offender, such as age, mental health, background, and previous criminal history, are also carefully weighed. Case law is rich with examples where such personal factors have led to adjustments in sentencing, either as mitigating circumstances that warrant a more lenient sentence or, occasionally, as aggravating factors. Furthermore, case law helps in the consideration of other relevant information, such as the impact on victims, the offender's behaviour post-offence, including any expressions of remorse or attempts to make amends, and broader societal interests. Through the examination of previous rulings, judges can find guidance on how similar factors have been weighed, ensuring that sentences are not only fair and appropriate to the individual circumstances, but also reflective of societal values and expectations. In Western Australia, the court has numerous sentencing options other than immediate imprisonment. At the lower end of seriousness are fines. The purpose of fines varies, including acting as a punishment for the offender, deterring them and others from committing similar offences, and sometimes compensating for the harm caused by the offence. At sentencing, the court may consider imposing a spent conviction. If the court considers the offending to be relatively trivial and the offender is of prior good character, the court may order that the conviction be spent. This means that the offence will not affect future employment prospects and will not show on a police criminal check. It's important to note that even though a conviction is spent, it doesn't erase the conviction entirely from an individual's record. The conviction remains part of the person's private criminal history and may be considered by police or courts in certain circumstances, such as when applying for a working with children check or when being considered for bail or sentencing for a new offence. The court may also impose a community-based order, which is a non-custodial sentence, allowing the offender to live in the community while under the supervision of the Department of Corrections. It can include requirements like undergoing treatment, participating in programs for personal development, or performing community service. The order, which can last from 6 months to 2 years, obliges the offender to report to a community corrections officer, follow their directions, and not leave the state without permission. Similarly, an intensive supervision order involves strict community-based supervision for offenders. It includes regular check-ins with a community corrections officer, participation in rehabilitation programs, and sometimes community service. The order is designed to aid in the offender's rehabilitation and reintegration into society. Non-compliance with the order's conditions can lead to the offender being brought back to court for resentencing, potentially resulting in more severe penalties. Lastly, even if the court is minded to impose a term of imprisonment, it may suspend the term of imprisonment it has imposed for a period not exceeding 24 months. The offender is allowed to remain in the community, but under the condition that they do not commit another offence, punishable by imprisonment during the suspension period. If the offender breaches this condition or is charged with an offence, they may be ordered to serve the suspended term in prison. Parole eligibility is determined by the court at the time of sentencing, in line with the Sentencing Act. For sentences of 4 years or less, prisoners must serve half the period in custody before they can be released on parole. If the sentence is more than 4 years, parole eligibility comes into effect 2 years before the completion of the total sentence. Being charged with a criminal offence is a complex and daunting experience for anyone. From being questioned by the police all the way to sentencing, it is always recommended to seek the advice of a lawyer who specialises in criminal law. However, the best advice any criminal lawyer can provide is to always remain on the right side of the law.